judge judgment or the 5-judge judgment would be a precedent, and the earlier one they would say overruled. Either it is overruled or silently it stands overruled. Therefore, unless a judgment of a 2-judge bench or a 3-judge bench is overruled by a larger bench, even the Supreme Court larger benches would be bound by the view that is expressed by the smaller benches. So law of precedence would apply equally to the Supreme Court also. Larger benches would be bound by views expressed by the smaller benches, unless the larger benches specifically say that the judgment of the smaller bench which is placed before me or relayed before me is wrong for ABCD reasons. Then the next question comes, if co-equal benches are hearing the case, one case has been decided by 2 judges or 3 judges, then the subsequent case comes up before the same strength, whether they are bound by it or they can differ. There may be a second circumstance also. There may be one 2-judge judgment, there may be one 3-judge judgment. The subsequent case is coming before 2 judges. 2 judges, they sincerely feel what the 3 judges have said is wrong and what the 2 judges have said is correct. But what is the subsequent 2-judge bench entitled to do? Supreme Court says that they are not entitled to say that the 3-judge judgment is wrong. I am convinced with the 2-judge judgment, therefore I am following the 2-judge judgment. They cannot say. Either they should follow the larger bench judgment, or if for reasons they feel that the 3-judge judgment is wrong and the 2-judge judgment is correct, then they will have to pass an order of reference, not directly to a larger bench to reconsider 3 judges. They will have to place it before the Chief Justice to constitute a 3-judge bench. And that 3-judge bench has to go into the question and identify whether there is a mistake in the 3-judge bench which is there. And only a 3-judge bench can refer it to a larger bench. In short, a smaller bench strength bench cannot refer the correctness or otherwise of a larger bench judgment by itself to the Chief Justice for being placed before a larger bench. Propriety requires that they will have to express their concern for strong reasons. Even that cannot be done simply. I don't agree, therefore I want to refer. It cannot be there. There has to be strong reasons to be recorded for that purpose. After recording strong reasons, it has got to be placed before the Chief Justice for placing it before an equal strength bench, and the equal strength bench may refer it to a larger bench. Thereafter, the decision of the larger bench whether it is right or wrong. This, the earliest one on this is, which often now is being cited, is 2005. 2005 2 SEC page 673, in the case of Central Board of Dawoodi Bora Community and another versus State of Maharashtra. Just note down paragraph 8 and 9. All this comes on the principle of stare decisis. There should be some certainty with regard to the judgments. Every week, every month, every year, we cannot be under guesswork whether this is the right law or not the right law. Therefore, there has got to be some consistency. In view of this consistency only, this formula or the method has been laid down by the Supreme Court. They say in paragraph 8, in so-and-so case, Chief Justice Pathak pointed out that in order to promote consistency and certainty in law laid down by a superior court, the ideal condition would be that the entire court should sit in all cases and decide questions of law, as is done by the Supreme Court of United States. Yet his lordship noticed that having regard to the volume of work demanding the attention of Supreme Court in India, it has been found necessary as a general rule of practice and convenience that the court should sit in divisions consisting of judges whose number may be determined by the exigencies of judicial need, by nature of the case, including any statutory mandate relating thereto, and by such other considerations which the Chief Justice, in whom such authority devolves by convention, may find most appropriate. Constitution Bench reaffirmed the doctrine of binding precedents, as it has the merit of promoting certainty and consistency in judicial decisions and enables an organic development of law, besides providing assurance to the individual as to the consequence of a transaction forming part of his daily affairs. Further, Constitution bench speaking through the Chief Justice Pathak opined that the question was not whether Supreme Court is bound by its own previous decisions. The question was under what circumstances and within what limits and in what manner should the highest court overturn its own pronouncements. In our opinion, what was working in the mind of His Lordship was that being the highest court of the country, it was open for this court not to feel bound by its own previous decisions, because if that was not permitted, the march of judge-made law and the development of constitutional jurisprudence would become to a standstill. However, the doctrine of binding precedent should not be given a go by. Quoting so and so, that is why they say that under what circumstances. Yes. His Lordship referred to several criteria articulated by Lord Reed. It may be useful to reproduce herein the said principles. I leave one. 2. A decision ought not to be overruled if to do so would upset the legitimate expectations of the people who have entered into contracts or settlements or otherwise regulated their affairs in reliance on validity of the said decision. Decision concerning questions of construction of statutes or other documents ought not to be overruled except in rare and exceptional cases. A decision ought not to be overruled if it would be impracticable for the Lords to foresee the consequences of departing. A decision ought not to be overruled if to do so would involve a change that ought to be part of a comprehensive reform of law. Such changes are best done by legislation following a wide survey and so on. So that is, the legislature has got wider discretion. Courts should always have consistency, and stare decisis should be followed by them. This judgment was referred to in two subsequent judgments, 2018 17 SEC, page 578. They say that do not unsettle the law. Para 28 and 29. In our opinion, that is on the facts of the case. In view of the aforesaid dictum and what is held by this court, we find that the prayer made for reference to a larger bench in the case, in case this court does not follow the earlier decision, is entirely devoid of merit, as on the basis of what has been held by this court in the earlier decisions, we have arrived at the conclusion. This court has authoritatively laid down in umpteen number of cases. Reliance has also been placed on behalf of the respondents on so and so, in which the court observed law should not be unsettled unless there are compelling reasons. There is no dispute that the proposition has already been held. There is no question of unsettling the law, but is of its application, which unfortunately appears against the interest of the respondents only. Therefore, unless there are compelling reasons, don't unsettle the law and don't keep making references to larger benches. And the same thing is said in 2020 7 SEC, page 509. Who can make the reference? Who can make the reference is spelled out in this judgment. Paragraph 22. It is true that decisions of division bench and full bench were challenged, and not only the special leave petitions but review petitions were also dismissed. All that was in the High Court. But as observed by the division bench in the instant case, the effect of Rule 13 of 1975 rules was not considered on earlier occasions. Since the division bench has now made a reference to a larger bench, we do not propose to enter into the matter and decide the controversy, but leave it to the High Court to consider and decide all issues. While saying so, they say, it was however submitted by the learned counsel for the appellants that going by the settled parameters of reconsideration laid down in Pradeep Chandra Parija versus Pramod Chandra Patnaik and so, no reference could and ought to have been made unless the earlier decisions were so palpably wrong or so very incorrect that the reference was called for, and in any case the reference ought to have been made to a bench of equal strength of 3 judges in keeping with the law laid down by the court in so versus so. That is through 2005 judgment which I referred to. Therefore, unless the earlier judgments is palpably wrong or so very incorrect, there should not be a reference, and such reference also should not be by a bench of smaller strength. This is so far as whether the Supreme Court can refer it to a larger bench or not. Then so far as when it comes to the High Court, in the High Court, when you are citing judgments, one is by 2 judges, the other is by 3 judges of the Supreme Court, which one are we to follow? The issue always, it will be very ticklish for the High Court judges to decide. Most of the seniors who are here may know that very serious problem was faced by the bar when anticipatory bail petitions. The Supreme Court Justice Arjit Pasayat, in one case, he said that anticipatory bail cannot be granted without limiting the time. Anticipatory bail, if granted, can be only for 30 days or 60 days. In the meanwhile, the accused has to appear before the regular court and move for regular bail. That judgment came up in 2007. Then all the high courts started following, and in our High Court also, the registry, honorable single judges, they started giving anticipatory bail only. Then a question was raised, and that question was referred to a full bench. Full bench presided over by Justice Balasubramaniam, R. Balasubramaniam, S.K. Krishnan, and Raghupati J. The 3 were there in the bench. Very excellent judgment, which is an eye-opener on how the High Court can authoritatively say a 2-judge judgment of the Supreme Court is wrong because there is a 3-judge judgment of the Supreme Court, and they were bold enough to say so by saying that we are not saying it on our own. The Supreme Court itself says how a High Court should act in such a situation. There, ultimately, they said that in 1976, Supreme Court has said that 438 is equal to the regular bail. Only thing is, he is not arrested earlier. Therefore, when he is granted bail, he is granted bail subject to condition. It is without any limit of period. If that is so, the subsequent judgment by 2 judges saying that it can be only for a limited period, it cannot be. This is wrong. Therefore, there is a 2-judge judgment of Supreme Court which according to us is wrong. There is a 3-judge judgment of Supreme Court which according to us is correct. Which are we to follow? They lay down and they say, paragraph 8, I'll read because it's very interesting. 2007, volume 4, CTC, page 1. We can have this handy whenever we refer to some judgments of Supreme Court which is larger in strength, and there are subsequent judgment which is lesser in strength. But there is one catch subsequent, I'll come to that now. Para 8, Salahuddin's case is the forerunner for all subsequent cases to conclude that anticipatory bail order could be only for a limited period. We find with respect that the judgment in Salahuddin's case is at variance with the judgment of the Constitution bench in Gurubaksh Singh Sibia case. We are not for the moment stating that the latter benches are without any power if they entertain doubt with regard to the judgment rendered by a larger bench. That is in the Supreme Court itself. A subsequent bench, it is not as if that they cannot raise doubt with regard to the earlier bench. Constitution bench of the Supreme Court in the judgment reported in Central Board of Dawood Bora Community versus State of Maharashtra. That is the first judgment which I cited, 2005 SEC Criminal, page 546, had laid down the procedure to be followed in such cases. But in the last 3 cases, namely Sunita Devi's case, Adi Dharan's case, and D.K. Ganesh Babu's case, we find that the honorable judges have not even doubted Gurubaksh Singh Sibia's case. Therefore, it is clear that the views of the court on the scope and ambit of section 438 of the Code of Criminal Procedure in Salahuddin's case, K.L. Verma's case, Sunita Devi's case, so and so, is at variance with the Constitution bench judgment of the Supreme Court in Gurubaksh Singh Sibia's case. In such a situation, what is expected of a High Court is again the subject matter of at least 2 judgments of the Supreme Court, and they are reported in Union of India versus K.S. Subramaniam. Note this one because this is very important. AIR 1976 Supreme Court 2433 and State of Uttar Pradesh versus Ramchandra, AIR 1976 Supreme Court 2547. On the law of precedents, the Supreme Court in both the judgments was analyzing the position of the High Court when it is faced with conflicting views of the Supreme Court and laid down the principles to be followed by the High Court in such circumstances. In AIR 1976-2433, the proper course for the High Court is to try to find out and follow the opinions expressed by larger benches of the Supreme Court in preference to those expressed by smaller benches of the Court. That is the practice followed by the Supreme Court itself. The practice has now crystallized into a rule of law declared by the Supreme Court. If, however, the High Court is of the opinion that the views expressed by larger benches of the Supreme Court are not applicable to the facts of the case, it could say so, giving reasons supporting its point of view. Then, AIR 1976 Supreme Court 2547, constitutional position as regard powers of court to go behind the orders of termination to find out the motive of the government is clear. Even in cases where a High Court finds any conflict between the views expressed by a larger and smaller bench of this court, it cannot disregard or skirt the views expressed by the larger benches. The proper course for a High Court in such cases is to try to find out and follow the opinion expressed by the larger benches of the Supreme Court in preference to those expressed by smaller benches of the court, which practice, hardened as it is into rule of law, is followed by the Supreme Court itself. From a reading of the judgments of the Supreme Court last referred to above, it is clear that the High Court has to follow the procedure indicated therein. If that procedure is followed, then this court has no doubt at all that it has to follow the Constitution Bench judgment of the Supreme Court reported in Gurbakh Singh, 1980 Supreme Court so and so. Therefore, they say that subsequent judgment, even though very recent, always there will be a temptation. Recent judgment has to be followed, recent judgment has to be followed. This issue was raised actually by the bar, saying that recent judgment says anticipatory bail for a limited period. Constitution bench says anticipatory bail is not limited. What are we to do? Therefore, the full bench was constituted. Fortunately, the full bench said, referring to two judgments of the Supreme Court itself, that in a situation where there are conflicting views of smaller benches and larger benches, the High Court should find out. You should not disregard the smaller bench judgment. You should refer to both and then find out that in the very same situation, larger bench has said like this, smaller bench has said like this. Therefore, with due respect, the judgment which is applicable and which should be followed is the larger bench judgment. That can be our plea, which in all probability will have to be accepted by the court. Therefore, so far as the law of precedence is concerned, larger bench will prevail. If a bench of co-equal strength finds it is not agreeable, then they may have to refer it to a larger bench. There may be a situation where there are two benches of same strength but taking diametric opposite views. In that situation, what is to be done? A subsequent bench can refer it to the Chief Justice for placing it before a larger bench. Ultimately, when it comes to the role of the advocates, our duty is to find out if on the same point there are judgments of judges of different strength. Our duty to place everything before the court and say that there is a larger bench view. Therefore, applying the principles of law of precedence, the larger bench view has to be followed. Only one exception to that now is that if there is a larger bench view and there is a smaller bench view taking some deviation from that, so far as the High Court is concerned, what the Supreme Court now says is that if the subsequent smaller bench has not referred to the larger bench at all, then you ignore the smaller bench. But if the smaller bench has referred to the larger bench, in spite of referring to the larger bench, if the smaller bench takes a different view, then they say that it is adding a clause to the earlier judgment of the larger bench, and therefore the subsequent view will prevail. Even though there is a larger bench, if the larger bench has been looked into by a subsequent bench of equal strength or a lesser strength also, so far as the High Court is concerned, it is applying that to 2007, our full bench. If the judgment in Salahuddin's case had referred to the Constitution bench, and in spite of referring to the Constitution bench, the subsequent judgment, they say that our anticipatory bail has to be only for a limited period. So far as High Court is concerned, they will be bound by that, because the smaller bench has already referred to the larger bench and then given its opinion and then taken a view. Whether that is right or wrong, High Court cannot say. That can be said only by the Supreme Court. Again, we go back, how it can be said by the Supreme Court. 2 judges can refer it to the Chief Justice for placing it before 3 judges. 3 judges can thereafter, if they are satisfied that there are compelling reasons, it is palpably wrong, then they can refer it to a larger bench. This is on the law of precedence. And so, I conclude my session today by just summing up that concentrate more on facts, go to judgments only when it is necessary, and one tip which I will give you is that even if you find a judgment 15% or 20% which may be against you, don't cite it. Don't. So, read the facts, read the judgment, you be confident that it helps you, and then only you cite it. Thank you very much.
Going by the senior's speech, Secretary, you could have given a tough topic for him. Is there any, now the question answer session, any advocate juniors wants to have any questions? ஆச்சி நீங்க ஏதாவது கேள்வி வேண்டாம் இல்ல என்ன கேக்குற
some single judge were referred, he refused to receive the judgment, not ignored to at the time of pronouncing. I am facing this single judge in our High Court. He referred, he received, he received, but it's not observed the judgment. Openly I say I will go to Supreme Court. No, that's why I need any judgment is there. Otherwise, senior having opportunity. See, we have written argument is there. My judgment is mentioned, but it's not.
That will be a ground for appeal.
Yes, grounds for appeal. But only one thing, if any precedent is there, the Supreme Court saying that.
No, see,
our duty to present.
see, whenever any judge, any case is being decided, the case has to be decided on the facts of the case, and when judgments are cited by the counsel, the judgment has to be cited, and reasons has to be given for accepting or not accepting. If it is not done, that may be a ground. See, law of precedence is also a facet of law. That is facts, applicable statutory provisions, and the third facet of law is the law of precedence. That is judge-made law. Judge-made law also is part of the case and is part of the list. Therefore, the court is bound to look into the judgments also. We can stop with that. If it is wrong, it's a ground for appeal.
Always now unsettled the settled laws, and we ask, we have become wiser than yesterday. Even in so many cases, suppose the bench decision is there, the meantime RDO passes some orders. Now the matter is referred to the larger bench. Whether the affected party challenge the RDO's order, or he has to wait till the larger bench decision.
That is also, I actually wanted to keep that judgment. Reference to a larger bench does not take away the precedential value of the judgment which stands as on that date. Suppose in the Arbitration Act, whether a document has to be stamped, whether it has got to be registered or not, that was the question which was very hot for long. That was referred to a larger bench, and larger bench has now answered it. In the interregnum, when a reference is pending before a larger bench, the Supreme Court says that the law until that day, till the reference is decided, what is the law as on that date, that will be binding. Therefore, nobody can say that reference does not amount to suspending the validity or the precedential value of the law which is there as it is. I'll give the citation.
Our Secretary will give you a vote of thanks.
Mr. President, Senior Advocate Om Prakash, and the today's hero, the Senior Advocate A.R.L.Sundaresan. I would really recommend you all to give a standing ovation for such a wonderful and amazing speech, because in 45 minutes, if somebody can give us so much of input, what kind of a knowledge he must have gained, what kind of a preparation he made. And also apart from that, at the beginning he just said, it was so humbly he said that it only for refreshing my memory and for refreshing my knowledge I just did. The kind of simplicity and humility all should understand. Legal knowledge is one thing, and the kind of humbleness to practice in the court is very, very important. So he taught us the very kind of a unique quality of advocate. Thank you, Senior, very much for your effort, and also even I was just really amazed, because I've attended so much of classes, and for 37 years of practice I've attended various, but in short span he gave us so much of inputs. Thank you so much. Thank you, everybody. Let us hope to attend more such classes, and we'll have a such program continuously for the whole year. Thank you very much, everybody. Thank you so much. Sir, thank you.
நீங்கள்லாம் வந்து உங்களுக்கு